All right, Steve, we are live streaming.
Okay, thank you. Welcome everyone to this meeting of the subcommittee to study the adoption of anti-discrimination language in the rules of professional conduct. We are meeting by Zoom again. Before we begin, I want to remind members of the subcommittee of their duty under the State Government Ethics Act to avoid conflicts of interest and the appearance of conflict, and members are instructed to refrain from participating in any matter coming before this subcommittee with respect to which there is a conflict of interest or appearance of conflict. Are there any acknowledged at the outset? I see none. The first order of business is approval of the July 8, 2021 subcommittee meeting minutes. That was the last time we convened. Do I have a motion on that?
Move that we accept the minutes as tendered.
Second.
Second.
Seconded. And all opposed? All in favor, all opposed? Okay. Meeting minutes are adopted from July 8, 2021. You all have seen, I guess, the balance of the agenda today. And before I turn it over to Brian, I just want to remind everyone where we are. The meeting on July 8th was devoted to consideration of the preamble to the rules. And it was this committee's recommendation that we move that up to the full ethics committee, and then in turn full ethics committee to the full council. And they were in fact, as I understand it, are ready for submission to the Supreme Court. That sort of cleared that issue off of our plate and puts us back, I guess, to the prior meeting, which was June 15th, to sort of get back on track in terms of the rule and what we may want to pursue in terms of any rule changes to deal with anti-discrimination. So that sets the table a little bit. At that time, we had considered language amending Rule 8.4 that would make certain violations of law, basically, against the rules of professional responsibility under this category of misconduct. And we had considered changes to 4.4, which is responsibilities to, is it third party? Yeah, respect for third parties, the rights of third parties. So that's where we are. We have seen proposed language for both of those rules, and I guess we're at the point where we need to decide again if we want to pick that up, where we want to pick that up, and I'll let Carmen and Brian. Well, we'll turn it over to Brian for an update on what's going on in Pennsylvania, and then Carmen and Brian for some further thoughts on where our discussions may go.
Sure. Thanks, Steve. The materials that you received this morning have an update from Pennsylvania. Of course, just that background, Pennsylvania adopted their own anti-discrimination language in their rules of professional conduct in 2020. It was that rule was challenged in federal court, and a federal district judge ruled their rule, or determined their rule, was unconstitutional in an order issued in December of 2020. Pennsylvania at one time was planning to challenge the ruling in the Third Circuit, but abandoned its appeal. And instead, you see here in your materials, on July 26th, the Supreme Court entered a new order amending or adopting a new version of Rule 8.4G. You will see, and I'm going to go ahead and share my screen so you all can see, we can look at the same thing here. The order itself, of course, appears on this page, and simply stating, exactly what they're doing, but paying attention here that their additions to the new rule are showed in bold and underlined text, and the deletions are in brackets. So following along here, you see their new 8.4G, they've added a mens rea to their rule, knowingly engage in that. Essentially, it's now stating that it's professional misconduct for a lawyer to, while in the practice of law, knowingly engage in conduct constituting harassment or discrimination. What they've taken out was the term knowingly, or I guess engaging in conduct by words or conduct that knowingly manifest bias or prejudice. Those terms are really the focus of the district court judge's opinion back in December. And so they've eliminated those terms, those phrases from their rule. The curious thing here, however, is that their comments that they've added to clarify the rule essentially put those words right back in there. I don't know how else to say it. I mean, I'll let you all take a look at their new rule and their comments and kind of let that speak for itself. But generally speaking, you can see down here their explanatory comment that they clarify, what does it mean to engage in conduct in the practice of law as this rule contemplates. And we're talking about, as you see here, interacting with witnesses, co-workers, court personnel, lawyers, and others, operating and managing a law firm, participation in judicial boards, conferences, committees, continuing legal education seminars, which was really the focus of the plaintiff in his challenge to their prior rule. And they expressly included new language that says this rule applies to CLE seminars. So it's just a curious thought process here. I've not heard from anyone from Pennsylvania. I haven't reached out to anybody from Pennsylvania to understand their thought process. But as you would perhaps not be surprised to hear, as you can see in your materials, about 3 weeks after the court adopted this new version, Mr. Greenberg filed another lawsuit challenging the constitutionality of that particular rule. The Pennsylvania bar has since responded. They just filed their response, I believe, last week. You see that in there as well. Of course, this is just at the outset of this litigation, but Pennsylvania stands behind its rule, the rule that it was adopted, and they stand against all of the assertions that Mr. Greenberg makes. So we'll probably head in a similar direction as far as it being not just in federal district court, but it's before the same judge to determine the constitutionality of their new version of this rule. I'll just leave those materials for you to review, just kind of an update. But Pennsylvania continues to be kind of the, I guess, a bit of ground zero for challenging the constitutionality of anti-discrimination rules. So I'll be happy to answer any questions you all may have, but otherwise, just I'll leave that for your entertainment.
Brian, this is Mac.
Yes, sir.
I'm curious whether you have an opinion about whether or not the district court opinion was correct or not.
Oh, goodness, Mac. I'll say I can see where the court is coming from. I think really to me, the flaw with the Pennsylvania rule, and maybe some of their arguments, there were some aspects where they refuted the claims that application of their prior rule really was constitutional, because they would never interpret it the way that the plaintiff was contemplating. And it really
that is a losing argument for sure.
Yes, yeah. So that's where I felt like, there was, as much as I see where they were going, I do see the constitutional problem with Pennsylvania's rule, and particularly with how they tried to defend their rule. So I ultimately think that, again, do I see where the court was coming from? Yes. On appeal, I thought it was kind of a coin flip of whether the Third Circuit would affirm the decision or if they'd reverse it. But I have to say that the amendments now, the so-called improvements to the rule, to me, are setting this up to be declared unconstitutional again. I'm going to be very surprised if the district court, the same district court judge, ends up finding this one unconstitutional. If anything, I feel like this probably has as many, if not more, problems. based upon the comments that they added.
That's what I thought too. I thought they made it worse.
Agreed.
Did they think that by removing any reference to speech that would remedy what they had proposed the first time out?
That's my guess that they, but you know, again, in the actual the comment itself, as I scroll down there, you know, you see that they're talking about, you know, they say that the term practice of law does not include speeches, communications, debates given outside the context in what they're I guess this scope of the rule. But they do. I think they send a pretty clear message that yes, conduct can incorporate speech, and I don't know that necessarily is the infirmity that just destroys a particular rule. I mean, again, the state bar, the rules of professional conduct do regulate speech.
Well, yeah, I mean, with that,
is a great example.
yeah, that is not going to win the day. The idea that no speech can be regulated. I mean, even our Court of Appeals has gone out of its way to say that that's not a legitimate First Amendment argument, to say that, you know, conduct that happens to occur in the form of mouth noises can't be regulated.
Right. So yeah, I think they thought taking it out of the rule, but still indicating that type of conduct would be covered by the rule via the comments doesn't really cure the deficiency.
I think it's safe to say that neither Brian nor I would recommend mirroring anything that Pennsylvania has come up with thus far.
Well, and also accepting the reality that no matter what we come up with, we're going to have a Greenberg here who's going to challenge anything we do. We just need to do the best we can do to get it, feel comfortable that we are framing a rule that meets constitutional challenges.
Yep. So Brian, what should we do next? Do you want me to?
Yeah, I'd say that's just the conclusion of the Pennsylvania update. Carmen, if you want to frame the discussion of kind of where we are now, where we left off, and where we should go today, that'd be helpful.
Sure. It seems like we, as a subcommittee, you all are arrived at a place of trying to decide how to proceed going forward, whether to continue with this as the same project that it has been all along, whether to disband altogether, whether to do something in between. You know, due to political circumstances, et cetera, it is not at all clear that anything even if the council were to adopt something, that it would eventually be enacted. And I think we need to be realistic about that. Brian and I do have some ideas about probably more limited, narrower rule amendments that would get at some of the issues this subcommittee has talked about, but are less likely to be controversial or less likely to be challenged. And so we just wanted to make sure we presented to you what those options are also. And probably the best way to do that would just be to go back to what we were working with the last time this subcommittee looked at the rule, as opposed to our sort of separate project on the preamble. So let me pull that back up just to refresh everyone's recollection of where we were, what we were talking about. At the last meeting, we were looking at a set of revisions that we believe captured the different types of anti-discrimination language that it seemed the subcommittee was interested in addressing. And the way we broke it down was to put some of the prohibited conduct in Rule 8.4 in what would be a new section of Rule 8.4, to put some of it in Rule 4.4, and then the issue of Rule 1.19 is something that is now in the hands of another subcommittee, so we don't have to worry about that. And the distinction here in the 8.4 and 4.4 proposals that you have looked at most recently is that the 8.4 proposals are would target specifically discriminatory conduct and sexual harassment, and the employment discrimination piece would be directly tied to definitions already existing in law, so we would not have to create our own definition or answer to questions of whether the definition is sufficient on that piece. It also included a prohibition on sexual harassment, but this proposal offered our own definition of sexual harassment in this context. And as you can see here, the proposal includes limitations on application also, which we think are necessary for any rules of this type. So as you can see, we're limiting, one of the biggest limitations here on how this would be applied is that for any employment discrimination issue, that would have to be adjudicated by the appropriate tribunal before it would become a disciplinary matter under the application of this rule. And this is the part, the Rule 8.4 amendments are the parts that we think might be more viable realistically in the current climate. The other proposed amendment that we discussed was a proposed amendment to Rule 4.4, which is in my experience a quite useful existing rule that captures just bad behavior, lawyers treating each other badly, treating court participants badly. It's a very valuable rule. And the suggestion was that we could include a bunch of additional prohibitions in Rule 4.4 that covered discriminatory actions by lawyers. This proposal, in our estimation, is going to be more difficult to get to a place where it not only gets through the council, but would also be adopted. So that's just a refresher on what we were looking at. Does anyone have questions about these proposals that are the last version before the subcommittee? Okay. Then I can share this again if that would be helpful during discussion, but for now, I feel like we should be able to see each other. Anything to add, Brian?
Nope, nothing further.
Thank you, guys. I would like at this time to open up the floor to a discussion of our direction. I'll just offer that, again, I think it's sort of, staff has come up with an elegant way to break down a couple of what the committee, this subcommittee to date has determined is problematic, can be problematic conduct at the bar, and put some part of it in Rule 8.4. And again, maybe the more nebulous part of it in Rule 4.4, but we have to decide, do we want to tackle one or both of these at this time, and be realistic about what we think we can get done and what might make it to the finish line. So thoughts on that?
Mr. Chairman, I think we need to do something. And I would probably take the advice that says the 4.4 rule is not the best way to do this. But I think it's incumbent on us to say the thing that we believe is right. And if it fails, so be it. But I think we owe it to the bar and to the public to attempt a thing.
I'm in agreement that we need to do what we think is right and not what we think is politically expedient. I think that we can have those political conversations and discussions at the council level. I think that for our subcommittee, we ought to be focused on what is the right answer and let the council work out what's the politically expedient answer.
Well, and hopefully we can persuade the council to stay on this right course. I believe it's the right thing. I think you're right. It's what the public expects of us. It's what the profession expects. And I think it's, there are always going to be people who might disagree with a particular course, but I think this subcommittee was formed for a reason. And I think we've worked hard. Carmen and Brian have worked very hard to look at the challenges and look at what is doable, what might pose a problem. And I am definitely against disbanding, and I am against standing up and doing the right thing, even if ultimately someone says no. At least we'll know we gave it every effort, and I think it is the right thing.
I agree 100%. And I won't belabor it by repeating.
Well, I would just observe that this subcommittee has been of that mind right along since we first deliberated. And I think absent any dissenting voices, we should at the very least forge ahead with wordsmithing on what Carmen has put on our screen a few minutes ago as concerning the amendment to Rule 8.4. Is there any further discussion about taking that path? Is there anybody who thinks it's not a good idea? Okay, onward and upward. Comments to the language as it is drafted. Well, Carmen, maybe you can, or Brian, break down one more time what the going back to the color-coded chart, what the sensitivities or the continuum of constitutionally acceptable versus unconstitutional, and how we attempted to deal with all those, I guess, beginning with in what capacity, which is the first part of the rule, the conduct is regulated.
Help me a little, Steve. I'm not exactly sure what you're asking.
Well, while acting in a professional capacity, what is professional capacity? We attempt to give that a definition. How does that definition fit in terms of along that continuum of conduct that the bars can permissibly regulate versus getting into conduct that the bar ought not to regulate?
So I know that we compared the phrasing that was included in various rules, like in, while representing a client, in a professional capacity, in the practice of law, it was phrased slightly differently in all these, in various rules. Some of them didn't seem to provide a comprehensive definition like the one that's on the screen right now. So there was a lot of variability. I think we tried to make this definition a little tighter than some by explicitly exempting purely social activities. But Brian, do you have any recollection on how we arrived at this definition? Like, were we patchworking from other states, or do you recall?
Yeah, I think that's what it was, and I think it's also important to point out that, comparing, for example, the Pennsylvania rule, that they're referring to, in the practice of law, and they have this very broad definition of what constitutes the practice of law or just participating in the practice. but that's really applying to their larger rule of discriminatory behavior knowingly, I guess, before manifesting bias and things of that nature. Whereas this rule, at the outset that's on your screen, 8.4, the proposed amendment to 8.4 really focuses on two things. One is the unlawful employment discrimination, as that term is defined in applicable law. And so that really is going to kind of restrict this professional capacity question, which has been a source of concern for those that have offered comment to us, or those that have written different scholarly articles about the constitutionality of these types of rules. But this, again, we're talking about first employment discrimination. So that's really going to be focused on the lawyer's operation of a law firm and kind of things of that nature. Where I think the term professional capacity really comes into play here is looking at sexual harassment. Because this rule is focusing on discriminatory behavior in the employment context, but then also sexual harassment. And so I think that's where you kind of have this question, maybe a discussion that needs to occur of carrying this out. We're talking about somebody who harasses somebody at a CLE program. That's not really kind of a focus on somebody's viewpoint, or potentially, I know a lot of the different comments that we received about curtailing discussion, debate about controversial issues. We're talking about harassing behavior, sexual harassing behavior in the context of being in a professional capacity, working at a law firm, interacting with folks in the legal process, participating in CLE programs, mentoring law students and lawyers, or participating in these official business of professional organizations. Is that what we're trying to do? Is that what we either will find acceptable or unacceptable? So I think maybe that's kind of I want us to have that framework and kind of maybe distinguish, because in a professional capacity has been a source of contention across these different jurisdictions and how they apply. But we're really only using that term for two specific ideas: sexual harassment and employment discrimination.
Right. And I think you're right, Brian. For purposes of this discussion, we can stop mentioning the employment discrimination, because that the context in which that occurs is clearly defined. That's not for us to define if we're tying it to law. So you're right. I think, and I believe that we crafted the capacity language to reflect what the subcommittee had to say about those hypotheticals early on in the process. And it was pretty clear that the subcommittee was not interested in trying to regulate tasteless behavior between lawyers at the bar holiday party. That was a bridge too far. And I think that is reflected in this definition. I'm sure we're kind of moving on from the question you asked, Steve, but I'm sure we will want to look carefully at any proposed definition of sexual harassment to make sure that, we probably should compare it to some other existing language, either in statute or in other jurisdictions' rules, just to see if we feel like this will stand up and covers what we want it to cover.
Carmen, this is Todd. I had that question about sexual harassment too, and precisely where did you guys draw the definition from? It seems a bit narrow to me, but I wondered, did you pull it from someplace particularly? I know you're talking about rewriting it, but is the one that's in here drawn from some particular place?
That is an excellent question. I feel like we did a lot of patchworking, and we didn't keep a record of where we were grabbing language from when we were putting it in here. I am sure that we did not come up with a creative writing style, but I'm sorry, Todd, I can't tell you off the top of my head where we found it. So if this is something that the subcommittee wants to look at, we can really dive in on that question of where did this come from? What other options are there? And I mean, I think we could probably have at least half a meeting's conversation just on that definition.
Well, the reason I ask is that we specifically say that unlawful employment discrimination is tied to the state and federal statutes and ordinances, and then we define sexual harassment here, and we're, as I understand it, we're not tying it to anything in the way that we are tying employment discrimination to the state and federal laws. And that's the reason I asked for the question. That's the reason I asked the question.
Yes, I think my recollection is that was intentional, in that the definition of sexual harassment in federal, it is also tied to employment
Right.
behavior. And so what we gathered from the subcommittee's analysis of the hypotheticals was that that would be too narrow to capture the kind of behavior that the subcommittee believed should be regulated, that it does occur outside of the employment context, and therefore we would have to create our own definition in order to apply it in other contexts as well.
Okay. But maybe something for you all to look at if that is the will of the subcommittee.
Absolutely.
I have some concern that the limitation on the employment discrimination is such that there will never be a bar action under that. If we can only take action against a lawyer after they've been found liable by a court of competent jurisdiction, that'll rarely happen. There will be settlements or dismissals or any number of other things that will happen that will not end in a judicial determination that a lawyer discriminated against an employee in the law firm. I think we've written that one so narrowly that there will never be a bar action based on it.
I tend to agree. I'm not aware of any lawyer who has been adjudicated to have engaged in employment discrimination. I mean, since I've been at the bar, I've never heard that being discussed. So I tend to agree.
Yeah, agreed.
It will encourage lawyers to settle those lawsuits if filed against them, so that there isn't an action against their law license after the judgment. But I think the way we've written it, it's going to be impossible for the bar to enforce that provision.
Agreed.
I guess just to offer maybe a potential counterpoint there, Mac, that I think the way that it's been written might actually make enforcement very clear, in the sense that the state bar isn't taking any sort of action until a court of competent jurisdiction has rendered its decision that somebody has engaged in employment discrimination. If that weren't there, and I guess I don't want to sound like I'm trying to advocate strongly for one or the other, but I think just a thought here is that if that provision wasn't there, it would saddle the Office of Counsel with reviewing claims of employment discrimination that the Office of Counsel will then need to investigate, vet, and reach its own determination, rather than going through the normal employment channels. And that's just a consideration of what types of claims are going to come in and what do we think the Office of Counsel has the capacity and resources for.
And
in other words, Catherine Jean does not want us to get into the business of litigating employment discrimination cases from scratch, which I understand.
I feel we specifically discussed that, but like you said, it's been a while, so I don't remember.
I think we did talk about that early on.
Yes. Okay. So Carmen, on that same point, we talk about application. This seems to be tied to employment discrimination. Did we deliberately omit something as to application in the context of sex harassment? I read 2A as sort of tying to the employment discrimination definition, and we've got a separate definition of sex harassment. I would think there might be a 2B that sort of says when it applies in the context of sex harassment, but maybe I'm just looking at it incorrectly.
I think Todd, I think your point is well taken. It may be more of an issue of how the content is arranged on the page, because I think our idea was that the rule itself states the prohibition on sexual harassment. The rule says sexual harassment while acting in a professional capacity is misconduct. But then that requires definition of both of those terms. And then the employment discrimination piece is taken separately and given a limited application. Does that make sense? I think it may just make it more clear if we rearrange things.
It does make sense. I sort of sometimes think of sex harassment as being encompassed by the phrase employment discrimination.
Yes.
That's what I understood as well.
Yeah, technically it is. That is true. That is true. And you know, in theory, I suppose some of these decisions regarding employment could also constitute sexual harassment, as that term is used in Title VII type litigation. So this, again, this is a working draft for sure.
And it's good. It's a good start, to be sure.
It is.
Carmen, is it possible to draft something that says that the application of this to sexual harassment is not bound by the application described in 2A? That is, that we can pursue a sexual harassment claim irrespective of a tribunal holding a lawyer responsible or liable.
Absolutely. And I think that would be worth doing, particularly to contrast it with the other part that is currently in there. So I think probably what Brian and I will do is go back and listen to the discussion in this meeting and use that to inform a revised version that we can bring to you next time.
Okay. Yeah, and I agree. I think, Mac, I think that's a good point to make that distinction. I think the concern about opening up the floodgates of every type of employment discrimination case would not apply as much to the general allegations of sexual harassment, although I'm sure it occurs, it's out there. But right. I think that I do share the concern of, if we did not rely on a court of competent jurisdiction and we just opened up used the disciplinary apparatus to regulate every type of employment discrimination, you're going to have disgruntled employees filing grievances against attorneys, and the resources of the state bar are going to be used. Right. So I do agree with Mac's point about maybe distinguishing as far as on the sexual harassment end, that we don't need a court of competent jurisdiction to make that determination for investigation purposes.
Right.
Any other comments on those aspects of the rule? I think that was a good summary, Alan, of Mac and Todd's points. And
I have a question. So, and Carmen, I know you better answer this quickly. So are we only limiting this rule to cover sexual harassment in this way, because we're also looking at the sexual conduct in that other rule 1.19 amendment on the other side? Because, okay, I just want to be sure.
Yes. So sexual, what would constitute sexual harassment under this rule when directed towards a client, we're going to address in the other subcommittee. So this is basically as applied to others encountered in a professional capacity who are not clients.
Okay.
I thought that was the answer. I just wanted to confirm, because I want to make sure this all is meshing together. Okay.
Other than those comments, is there anything else we want staff to consider in a redraft? I have one question, if no one else does. But let me see if anyone else.
Are you just on 8.4? Now I've got one question about 4.4.
Just 8.4, I think, Todd. I think we want to focus in on 8.4 for now.
Nothing from me.
Thank you. The one question I had for staff is, and again, it goes back to where you pull the definition from, maybe, but what I'm not sure what implicit or explicit means. I guess we could come up with examples, but probably easier to find examples explicit than implicit, but that's just the workings of a.
That actually, that Steve, to me, that looks like one of those phrases that looks like any and all. It looks like one of those phrases that lawyers put into sentences that are entirely unnecessary. If, you know, I don't think the meaning of this changes if you just say attempts. Take
Yes.
that out, you know?
All right.
Okay. Yeah, I agree.
So I have another question, and I asked that question earlier about the rule 1.19, but I want to make sure I'm clearing this up for myself too, and we may have gone over this before, but we specifically pulled out sexual harassment here from that unlawful employment discrimination so that we can cover all those instances. But did we really want to just intend to cover harassment as in repeated behavior, persistent behavior, as opposed to what if the employer makes an advancement that's not persistent, but it's a one-time thing, you know, that wouldn't necessarily constitute harassment, but would constitute discriminatory behavior still, but it's not persistent. And it doesn't seem like that would be covered. And that's what I was trying to reconcile. Are we looking to cover that over in the, because I know that one is more explicit in that rule 1.19, you know what I mean?
Right, that is, well, in 1.19, it doesn't have to be repeated. It can
Exactly.
be a single instance. I think that's something for the subcommittee to discuss, you know, how that trying to balance capturing actionable conduct versus capturing too much. And so I think that's one of the challenges of drafting this definition, but your
Carmen?
point is well taken.
Carmen,
I
this
just
is
want to
Matt.
throw that, yeah, I just want to throw that out there because I get why we want to cover harassment, sexual harassment, but I don't want us to miss covering that instance that somebody may have done that one thing, that one time, but it did actually cause work conditions contingent, you know what I mean? All the other portions of this still applies, but it's just not persistent.
Mhm.
Well, in Title VII jurisprudence, there are two ways to violate the prohibition. One is persistent, the other is severe. So we could look at putting the concept of severe or persistent into there.
Mhm.
And Mac is right, because there is some law that, you know, a one-time offense is not necessarily violative of Title VII unless it is, as Mac says, very severe. So that's sort of getting into that enforcement area again of, you know, what is the definition of severe, but it's maybe just unavoidable. But Mac makes a great point. Maybe that's the way to capture your one offense comment, Dorothy, to say certainly one offense can be severe and severe enough to violate Title VII, for example. Mac makes a great point.
I'm glad y'all are so well versed in Title VII because that's one area I'm not as, yeah.
I'm not. I know enough to be dangerous. That's
all we need. Make good trouble.
All right. Okay.
So Steve, did you want us to just focus on Rule 8.4 for now and for the return to the committee and then maybe have a separate discussion on 4.4? I wasn't sure what you had in mind.
That was my thought, but Todd appeared ready to be.
I just had one question. I mean, and it's in 4.4B. You have put in the language conduct that manifests bias or prejudice. I thought from looking at the Pennsylvania case, that's precisely what the district court judge held to be unconstitutional, and therefore in the amended version that the Supreme Court adopted, they eliminated that language. And if I'm erroneous, that's great, but if that's exactly what the federal district court judge found offensive. Is it prudent to stick that language in here?
I think, yeah.
No, no, the answer is no. It is not at all prudent. I don't remember, Brian, did the judge I mean, I know they did take it out. Did he specifically say that phrase is infirm in some way?
Well, not necessarily, but that was something that the litigants really pointed out as to what exactly does that mean. The thing that you will see, though, is that phrase is in many other jurisdictions, definitions, whether we're talking about the rule or the comment that expands the coverage of Rule 8.4D as far as what is prejudicial to the administration of justice. But the court's decision really focused on the notion that this did cover speech and focusing on that First Amendment right. I think there were concerns expressed about the vagueness of knowingly manifesting bias and so forth. And that's why I think Pennsylvania adopted this kind of just blanket knowingly engage in discriminatory conduct. So it's nevertheless, I think that phrase still does present some problems. We included it in that first working draft, but I think Carmen and I have both arrived at the same place that there's got to be a better way to capture what we're talking about. And the lawyers deserve to know exactly what this rule is supposed to be talking about, what it's supposed to be addressing. So yeah, I think you're right, Todd, that phrase probably needs to go away.
Yeah, and it is also one of those phrases that sounds unnecessarily lawyer authored, right? I mean, that's a lot of words to say what I think is trying to be said. So I'm sure we can do better.
As you do better, I hope we don't draw it so restrictively that once again, we've written a rule that will never be applied to anybody because it is so narrow and so strict.
Yeah.
This is that part where I thought the Pennsylvania court was correct in striking down some pieces of their rule, but went too far in striking down pieces that I thought were not wrong.
Right. Yeah.
It's been known to happen.
Yes, ma'am.
Absolutely.
But it shouldn't happen from us. We should land in that appropriately defined position that allows us to get at the conduct that we're trying to discipline.
Yeah. Steve, that's the only comment I had on that. I'm sorry if I got off course here.
No, thank you, Todd. It does bring us back to the bigger question of how much does this subcommittee want to tackle, and having heard the strong comments from Ted and Mac up front that we want to continue our work. I suggested maybe we just confine it to 8.4 and we make some recommendations on those employment and sexual harassment based approaches. But if we want to, I'll throw it out there again. Do we want to continue plowing forth and address 4.4 as well, even though it's it deals with all conduct concerning third persons throughout our profession and the people we deal with, or do we want to stay confined to the more limited 8.4 considerations?
Could we wait to see what Brian and Carmen come up with as a better rewrite of that before deciding whether to jettison that part of it? Sure.
Yeah, that's a good suggestion, Mac. And again, this is a fluid group and a fluid conversation. I'm open to, and I think staff has encouraged me and us to decide for ourselves where we want to go, what direction we want to go, how much we want to bite off. And there are a lot more challenges and questions in the 4.4 part of it, but I sense no reticence on the part of the committee members to keep on going. We set it only an hour aside today, so I would urge that we all think about that going forward. Ask staff to do a rewrite of 8.4H, and we'll find a time to reconvene.
Great. Okay. Yeah. I mean, we will revisit, because Brian and I generally, once we get into something, we can't really stop. So we will revisit all of it probably. And then you all can decide how you wish to go forward, but we will revise both.
Thank you.
The other discussion I had with staff is that you all are highly qualified people in the profession. You're busy with many things, and while we don't want to keep on paddling where the destination may not be much in sight, again, I'm hearing everyone willing to participate and devote their time, and I much appreciate it. And I think it's good work. Maybe some good trouble too, Dorothy.
Well, it's an ethics conversation. We could stretch this out a couple of years.
Easy, Mac.
Good.
All right, unless there's anything else, I'm ready to entertain a motion to adjourn.
So move.
Ooh, second.
Thanks, everybody.
Thank
you,
you.
everyone.
Thank you.
Have a good evening.
Thank you, Carmen and Brian, for the work.